Hello students and welcome to week 4. This lecture is going to cover the review of your midterm exam, which consisted of the 15 multiple choice questions. I know I did indicate to you all that this lecture would have been posted on an earlier date. However, I had to wait until everyone submitted their midterm before I uploaded this lecture because, of course, in this lecture, I will be discussing the correct answers. Now that I've received everyone's submission, and I believe you all have also received your scores as well, I can now proceed with uploading this lecture. So I'm going to begin with question number 1. They may not be in the same order in which you took them because I did set it up for the questions to be presented to you in random order. So I'm just going to go over them in the order in which I submitted them when I created this exam. The first few questions deals with the standards of review, strict scrutiny, intermediate scrutiny, and rational basis. And I'm going to spend some time explaining these standards because I don't believe that the book does a very good job of clarifying these standards or at least helping you to understand how they come into play. So I'm going to spend a few minutes on that. And if after this lecture, the standards are still unclear, please reach out to me and I'll try my best to clarify any questions that you have. Okay, so let's start with question number 1. Question number 1 reads, for equal protection purposes, the blank standard is used to determine the constitutionality of a government action based on age. Now, as you know from your text, you can find this information in Chapter 2. Chapter 2 discusses the standards for review, and based on your readings, you know that if the regulation or the government action is based on age, then the rational basis standard will be used to determine its constitutionality. So the correct answer is D, rational basis. Question number 2. When a government classification intentionally discriminates on the basis of gender or legitimacy, the classification will be found unconstitutional unless the government can prove that the classification is at the least substantially related to an important government purpose. That answer is C, and you can also get that information from Chapter 2, Figure 2.3, which lists the Equal Protection Clause standards of scrutiny. Question 3. Now, this question, I received a lot of feedback from you all about this question, and one of your classmates and I even had a discussion about this, and I must commend him for contacting me and arguing his point. He believed that the correct answer, and many of you believed that the correct answer should have been A, prohibits substantially more speech or speech-related conduct than is necessary to achieve a legitimate government interest. Now, that answer is incorrect. A is not the correct answer. But if anyone selected that choice, I gave you the 5 points for that because I feel as though the book didn't do a very clear job at illustrating how these standards apply to free speech regulations, and I don't believe I covered it in great detail. I know that I did go over an example with respect to an overbroad regulation. However, that example did not apply to free speech. So with the example that I provided, the example that was in your book, as well as the explanation of an overbroad regulation, I said that I will accept that incorrect answer because I can see why you all would have chosen it and everyone chose it. But for the record, that answer is incorrect. The correct answer is what was listed, D, that the overbroad regulation under the free speech clause cannot be enforced against anyone. And here's why. In the call of this question, you see the word regulation. The question is, under the free speech clause, an overbroad regulation. So from the time you hear that, you should start thinking, okay, this has to do with a regulation. Which standard of scrutiny applies? Because as I've told you before, this is where these strict scrutiny standards come into play. And let me pull them up here. Okay, we have strict scrutiny, which is the most difficult level of scrutiny to bypass. In order to bypass strict scrutiny, you must show that the law is narrowly tailored to serve a compelling government interest. If intermediate scrutiny is the level of scrutiny that's going to be used to determine the constitutionality of the regulation, you must show that the law is substantially related to an important government interest. And if rational basis, this is the least difficult level of scrutiny to pass. If rational basis is the standard that we're using, then you must show that the law is reasonably related to a legitimate government interest. Now, we've already discussed that if the regulation is discriminating against someone based on their national origin, then in order for us to determine whether that regulation is constitutional, we must apply strict scrutiny. And it says that in your book, okay? It says that in chapter 2 under standards of scrutiny in equal protection cases. Specifically, it says, if a law classifies people based on race or national origin, it is unconstitutional unless the law is narrowly tailored to serve a compelling government interest. That is the test for strict scrutiny. The example I gave to you was there is a regulation that states you must be born in the United States in order to run for president. If someone who was not born in the United States decides that they want to run for president and they feel as though they're being discriminated against based on their national origin because they were not born in this country, and they decide to file an equal protection case, an equal protection suit, the standard that the court will use to determine whether or not that law that says you have to be born in the United States is constitutional is going to be strict scrutiny. Okay? Your book says that if the classification discriminates based on gender, intermediate scrutiny will be used. So if you see a law that says, well, this only applies to males or this only applies to females, and the other gender wants to file an equal protection suit, then intermediate scrutiny is the standard that the court will use to determine whether or not that law is constitutional. Anything else, such as sexual orientation, age, if the regulation is discriminating against that, if it's discriminating against age, sexual orientation, then rational basis is what we will use as the test to determine whether or not that law is constitutional. And the example that I gave to you was that the legal drinking age in the United States is 21. So if someone who is 18 years old decides that they want to bring an equal protection suit because they're 18 and they're not 21 and they're being discriminated against because of their age, rational basis is the test that will be used to determine whether or not that law that says you have to be 21 and older is constitutional. Okay? Now, when it comes to free speech cases, any regulation that prohibits the content, certain content of speech must pass strict scrutiny. Okay, so this is how these standards of scrutiny come into play with the free speech clause. So the standards of scrutiny that you just saw, strict scrutiny, intermediate scrutiny, rational basis scrutiny, they don't just apply to age discrimination cases, gender discrimination cases. They also apply to free speech cases. So we know that under the First Amendment, we have free speech. But as you've learned from your reading, not all speech is protected by the First Amendment. The government does have the right to regulate certain types of speech. However, if they're going to regulate the content of the speech, okay, if the regulation is going to address the content of what you can and cannot say, then that regulation must pass strict scrutiny. So when we get to this question here, the overbroad regulation under the free speech clause, everyone selected A, but only half of option A's answer is correct. It is true that an overbroad regulation prohibits substantially more speech or speech-related conduct than is necessary. However, this must be subject to strict scrutiny. And the test under strict scrutiny is the law must be narrowly tailored to serve a compelling government interest. In your question, it says necessary to achieve a legitimate government interest. So this part of the question is wrong because it has incorrectly stated the test for strict scrutiny. And strict scrutiny is what must be used to determine whether the regulation is constitutional or not. Now, if it is determined that a regulation is overbroad, it cannot be enforced against anyone because it is unconstitutional. And that comes from the example, or it can be illustrated from the example in your textbook, rather, under the void for overbreadth doctrine. So under that, there's the example that I talked about before, a law that criminalized starting a riot and saying anything bad about the President of the United States would be overly broad and unconstitutional. And we know this because we know that starting a riot is the conduct that is outlawed. But saying something bad about the President of the United States is not outlawed. You are allowed to do that to an extent. So to have both of those things be outlawed, starting a riot and talking bad about the president, that is overbroad. That regulation is prohibiting you from doing things that you're allowed to do under the Constitution. It's unconstitutional because it's overbroad. It's prohibiting substantially more speech or speech-related conduct than is necessary. But if it can pass strict scrutiny, then it will be constitutional. But in this case, in this answer choice A, it incorrectly lists the tests for strict scrutiny, and that's why that answer choice is only partially correct, and the correct answer choice is D, meaning under the free speech clause, an overbroad regulation prohibits substantially more speech or speech-related conduct, and therefore cannot be enforced against anyone because it's